If you own a rental property in Washington, D.C., the rules just changed. And if you're not up to speed, you could be facing fines, lawsuits, or worse. Serious. I'm BJ, owner of Real Property Management DC Metro. Today, I'm walking you through the most important DC landlord tenant laws you need to know right now in 2026. Number 1, the Rental Act is now in effect. Informative. The Rebalancing Expectations for Neighbors, Tenants, and Landlords Act, officially DC Law L26-0080, took effect December 31st, 2025. This is the biggest update to DC housing policy in years. It changes eviction procedures, tenant notice requirements, rent control calculations, and lease non-renewal rules. If you haven't reviewed your leases and processes since this law passed, you need to do that today. Urgent number 2. Rent control caps for 2026 have been published. If your property is rent controlled, the DC Rental Housing Commission has set the 2026 caps. For standard tenants, the maximum rent increase is 4.1%. For elderly or disabled tenants, the cap is 2.1%. These caps apply to any rent increase taking effect between May 1st, 2026 and April 30th, 2027. Violating these caps exposes you to tenant complaints and potential penalties with the Rental Accommodations Division. Number 3. Security deposit rules are strict. Under DC Municipal Regulations, Section 308.2, you can charge no more than 1 month's rent as a security deposit. You must return it, with interest, within 45 days of move-out. If you withhold any portion, you must provide a written itemized statement. If you withhold in bad faith, DC law allows the tenant to sue you for 3 times the deposit amount. That's Section 309.5 of the DCMR. Number 4, rent increase notices have tight deadlines. For month-to-month tenants, you must provide at least 45 days written notice before a rent increase takes effect. For rent-controlled units, you must also file the increase with the Rental Accommodations Division. Miss these deadlines, and the increase may be unenforceable. Number 5, good cause is now required to not renew a lease. Under the Rental Act, you can no longer simply choose not to renew a lease without a documented legitimate reason, such as substantial rehabilitation or owner move-in. This applies to a broader range of housing situations than before. Failing to have a documented reason could expose you to legal challenges from tenants. Number 6, evictions now require mediation first. Before many eviction cases can proceed, even for non-payment of rent, the Rental Act now mandates a formal mediation period. You must engage in good faith negotiation with tenants facing financial hardship before filing. The pre-filing notice period for non-payment cases has been shortened, but the mediation step is new and mandatory. Look, DC landlord tenant law is complicated, it changes frequently, and the penalties for getting it wrong fall entirely on you as the property owner. This is exactly why we exist. At Real Property Management DC Metro, staying current on DC and Maryland law is part of what we do every single day, so our clients never have to worry about compliance. If you want to make sure your rental property is fully protected under DC's 2026 laws, visit us at rpmdcmetro.com and get your free rental property evaluation. No cost, no contract, no pressure.